अपने बच्चों के मुस्तकबिल को दें एक मजबूत बुनियाद। वेलकम टू फेडरल पब्लिक स्कूल CBSE। यहाँ मिलता है वाइड प्लेग्राउंड जहाँ बच्चे सीखते हैं टीम वर्क और फिटनेस, मॉडर्न साइंस और कंप्यूटर लैब्स के साथ प्रैक्टिकल लर्निंग का बेहतरीन इंतजाम। सिर्फ तालीम ही नहीं बल्कि सिंगिंग, कराटे और योगा जैसी एक्टिविटीज से कंप्लीट डेवलपमेंट। हाईली क्वालिफाइड और केयरिंग टीचर्स जो हर स्टूडेंट पर इंडिविजुअल फोकस करते हैं। और अब हॉस्टल फैसिलिटी भी अवेलेबल, सेफ और कंफर्टेबल एनवायरनमेंट के साथ। LKG से लेकर 12th तक कंप्लीट एजुकेशन अंडर वन रूफ। एडमिशंस ओपन है एकेडमिक ईयर 2026-27 के लिए। आज ही ज्वाइन करें फेडरल पब्लिक स्कूल CBSE, जहां सपने बनते हैं रियलिटी।
दरवेश ग्रुप केस के मामले में हाल ही में सोशल एक्टिविस्ट अंबाजी, मोहम्मद मसूद और इन्वेस्टर्स की जानिब से किए गए एहतजाज के बाद कल एक बार फिर से इस मामले की सुनवाई कलबुर्गी हाई कोर्ट में हुई। लेकिन कल की सुनवाई में क्या हुआ, इससे पहले ये जान लेना जरूरी है कि इस केस में पब्लिक प्रोसिक्यूटर और पेटिशनर के एडवोकेट्स के अलावा कुछ और एडवोकेट्स भी शामिल हैं। इनमें एडवोकेट दिवाकर और एडवोकेट कलीम खास तौर पर काबिले जिक्र हैं। एडवोकेट दिवाकर रेस्पोंडेंट नंबर 2 यानी कंप्लेनेंट चंद्रू की तरफ से पैरवी कर रहे हैं, जबकि एडवोकेट कलीम रेस्पोंडेंट नंबर 3 यानी कंप्लेनेंट समरीन बेगम की तरफ से कोर्ट में मौजूद रहे। कल की सुनवाई के दौरान एडवोकेट कलीम ने कोर्ट से दरख्वास्त की कि उनकी एप्लीकेशन को गौर के लिए रखा जाए और इन्वेस्टिगेशन ऑफिसर को पेटिशनर्स को गिरफ्तार करने की हिदायत दी जाए। वहीं दूसरी जानिब एडवोकेट दिवाकर ने कोर्ट को बताया कि इस मामले में सेटलमेंट की गुंजाइश मौजूद है। उन्होंने अग्रीगोल्ड केस का हवाला देते हुए कहा कि उस मामले में एक रिटायर्ड जज की सरपरस्ती में तकरीबन 5,000 करोड़ रुपए इन्वेस्टर्स को वापस दिलाए गए थे और इसी तरह ये कोर्ट भी अगर मुनासिब समझे तो इन्वेस्टर्स को राहत पहुंचाने के लिए एक मुनज्जम स्कीम पर गौर कर सकती है। एडवोकेट दिवाकर ने कोर्ट से मोहलत की दरख्वास्त करते हुए कहा कि अगर वक्त दिया जाए तो एक ऐसी स्कीम पेश की जा सकती है जिसके जरिए इन्वेस्टर्स को राहत मिल सके। इस पर पब्लिक प्रोसिक्यूटर एडवोकेट मकबूल अहमद ने कोर्ट को याद दिलाया कि पिछले साल यानी 10 जून 2025 को कोर्ट ने पेटिशनर्स को इन्वेस्टिगेशन ऑफिसर के सामने हाजिर होने का हुक्म दिया था, लेकिन उन्होंने उस पर अमल नहीं किया। बहरहाल दोनों जानिब के दलाइल सुनने के बाद मोहतरम जज साहब ने पेटिशनर्स को सख्त हिदायत दी कि वो 10 जून 2025 के अदालती हुक्म के मुताबिक इन्वेस्टिगेशन ऑफिसर के सामने विदाउट फेल हाजिर हों। कोर्ट ने साफ तौर पर कहा कि ये उनके लिए आखिरी मौका होगा। अब इस मामले की अगली सुनवाई 22 जून 2026 को होगी, जिस पर इन्वेस्टर्स और आवाम की नजरें टिकी हुई हैं। उम्मीद है कि सभी इन्वेस्टर्स को जल्द से जल्द इंसाफ मिले और वो सब राहत भरी सांस और सुकून भरी मुस्कुराहट के साथ जिए।
Senior counsel is appealing on the behalf of pleading applicants, Lordship. Lordship kindly consider.
Yes. Lord, in this case, I am appearing for respondent number 2. A case was registered in Raichur Sen police station. Yes. Under the provisions of banning of Unregulated Deposit Schemes Act. The petitioner, my learned friend whom he is representing, there are 15 accused persons, my lord. Out of this, 1, 2, 3 are the partners in a company called DARWESH company. Yes. A case was registered against them for collecting the deposits from the general public, promising 10% of returns on them, and they failed to pay the principal and deposit as together. A case was registered. When the case was registered, though there are more than 3,000 depositors, only 2 cases have been registered. One case has been registered in which I am representing R2. My learned friend is representing a petitioner. This honorable court is a 2024 matter. This honorable court has passed an ad interim stay. For that reason, the progress of the case has been stand as it is. My humble submission, my lord, this is a special act. They have been taken the deposits from the general public. The object and reasons of these acts is the amount should be refunded back to the depositors. But the process in which the both KPID Act as BUDS Act states that the state government has to appoint an authorized officer, and authorized officer has to secure all the deposits and the properties and disposed of pro rata he has to give it to the depositors. Our experience as court officers, my lord, in IMA case, in Raghavendra Bank case and other cases, for years together, these notifications and officers are not taking responsibility. Even changing of quotations of the guarantors as well as the purchaser, it will take years and years. My humble submission now, because of all these depositors are below the poverty line people, they all belongs to, and there are 13 crore rupees a bank amount has been freezed, and there is a property worth about 100 crores in and around Raichur. There is even the petitioners before this court who has obtained the stay order, they are ready and willing to pay back the amount to the depositors. And depositors also, they have suffered for pillar to post for the last 4 years. They have suffered. They have not seen any light out of the tunnel. Hence, my humble submission, my lord. Now the charge sheet has been filed in the BNA under CA. The case was transferred to COD, and COD has filed a charge sheet. Now, option open for your lordship now. Under chapter 23, plea bargaining is there because the charge sheet has been filed. At the same time, there is a lok adalat is also there. Petitioners are ready and willing to refund the amount by disposing the property, but it has to be monitored by some responsible court officer or district legal service authority. Hence, my humble submission, because of this stay order, they are neither in the position to dispose of the hands of the officers have also been tied, even though they have been notified, nothing progress has taken place. My humble submission before lordship is this matter, a joint memo we are ready and willing to file on behalf of the depositors as well as the petitioner. We will give a scheme how we are going to dispose of the property and pay back to the depositors, monitored by the court or by a legal service authority or by a retired district. In Agri-Gold matter, Andhra High Court appointed former judge of Andhra Pradesh High Court, where the deposits of more than 5,000 crores was refunded back. It took 1 or 2 years, court monitored. Hence, my humble submission, we are ready and willing to give a scheme. A week's time may be given. We are ready and willing to give the scheme to the perusal of this honorable court. This honorable court, in view of the chapter 23, plea bargaining is a provision available in BNS. Already charge sheet has been filed, either under section 23 of the plea bargaining act or under the Lok Adalat Act. This problem needs to be solved and depositors should get back the money. Hence, my humble submission before lordship is, we are ready and willing to give the scheme of there is 13 crore deposit has been frozen by the police officers, and there is a sufficient property, all the documents have been marshaled and it has been filed along with the final report filed before the court. Yes. The property is worth of 100 crores. The total deposit is 95 crores. The administrative expenditure may be 40 to 50 lakhs, where some retired district judge or somebody may be appointed to monitor. We don't need anything to be, even the bank account also, the petitioners are not ready and willing to handle. The depositors, ultimately, they will not get the 10% interest or anything. At least the principals, if they are able to get it, 5 lakh, 20 lakh, from 50,000 to 5 lakh, there are more than 2,000 depositors. Major depositors are less in number. And property is in around Raichur. Hence, Raichur is either Raichur District Legal Service Authority or some retired district judge appointed by this honorable court. If the monitor, at least in the 3-4 months, the entire problem will solve.
You furnish a scheme under which it should be.
No, scheme is there. Notification scheme is the scheme we are ready and willing to submit to the court. Court can peruse under plea bargaining, whatever scheme we are giving under 290, this court has to consider and appoint some responsible officer. In some cases in South Canara, in Udupi, the district legal service, the amount may be less, but the services of the district legal service authority secretary was ensured, and he was in account was opened, monitored by DLSA and some revenue officer. The scheme has been in the Baindur Taluk, it has been solved. Hence, the same scheme we are ready and willing to give to this honorable court. A week's time may be given. Myself and the petitioner council will submit the scheme. If the court accepts it, there will be a smile on the face of the depositors.
Yes,
I totally agree with senior counsel, Lordship. Even my intention is to disperse the entire liability. So my humble submission, Lordship, the procedure which already is given in the law, it is little cumbersome, and from our experience, I can say that immediate result will not be there. So that what the senior counsel has submitted, we'll sit down and we'll formulate the scheme.
You are appearing for respondent.
No, I am for the respondent. I am appearing, and I also had a discussion with the petitioner's counsel in Bangalore. My learned friend who is appearing for the petitioner's counsel, we had a discussion because here our paramount interest is not more than getting a justice or conviction, because even the offences which have been invoked, my lord, are compoundable in nature.
21.
They are compoundable in nature. Punishment is not compulsory. But my humble submission is the quest of justice and chapter 23 plea bargaining. This is the new found which was not there in earlier APs, my lord. We are submitting a scheme which, because under Article 226 or 482, this court has got ample power to direct. And we are directing, we are not asking whether it has to be directed for a retired panel of legal officer or mediation or district legal service authority, whichever agency this court feel effective in getting justice to the depositors. Maybe a week's or 10 days time may be given. We'll submit a detailed.
I may be heard, Lord. I am appearing for respondent number 1 investigating agency, Lord. In this attempt only, even we agreed and we attempted, we gave the consent to the court that this such a scheme can be evolved. Lord, your lordship may see the order sheet dated 10/6/2025. Though the concern appears to be genuine, but there was no supportive conduct from the petitioner. They have wasted the time of this court, and finally they said that
such a submission before the court.
No, my learned friend, I did not interrupt you when you were submitting.
Yes, yes.
No, it's the view of my friend.
And my lord,
I agree.
as far as victims are concerned, it is not 2,000 victims. We have investigating officer has identified 10,200 victims, my lord. If they come up with this saying that 2,000 victims, where the rest of the victims have to go?
No,
Finally, we have to, if your lordship is to go for that, my lord, that attempt has been already made by this court, which has not brought any fruits. Kindly see the order dated 10/6. I may be permitted to complete, my lord.
My lord, the first time I am appearing in this court, 2025.
I will read it after completion of senior counsel.
There may be an attempt, a failed attempt. There may be a trial and error in that case, my lord. What I am praying this honorable court, I am not asking for the time, indefinite time. A 10 days time may be given. We will give the scheme. If it is acceptable to court, it's acceptable. If it is acceptable to court, at the larger interest of the depositors. My only submission is, my apprehension is, a authorized officer, investigation agency will not see the light. The investigation officer's mentality will go towards the conviction of the errand people. Accused, whoever accused, they have to be convicted. That is the mindset of the investigation agency. My humble submission, plea bargaining which has been imbibed in the new BNSS, my humble submission, legal service authority, mediation, the alternate dispute resolution mechanism has evolved. So even Supreme Court has made an example number of cases.
Unless the actual victims are...
No, my lord, the identification of victim and identification of victim as well as disposal of the payment, both has to be done. We are ready and willing to give the proposal of the amount available and how we are going to the deposits which are with us. If my learned friend or state is going to give the depositors list, if they help the court in resolving the issue by giving the list of depositors and the amount involved, we are ready, and the amount, the total amount payable to the depositors and the property deposit available, my as an officer of a court, my lord, my assessment is that it is sufficient enough to pay back every penny to every depositor. That is my submission. I will give the scheme. How we are going to give it, it has to be monitored by the court. Whoever depositors are there, let them give the list. For everyone will give.
Ultimately, the depositor should not supply.
No, not even single depositor. My lord, only thing here what happened, that 10% interest what the promised by this petitioner is impossible to pay. But however, if the amount is available more than...
They may not be interested in punishing the accused.
No, we are ready to pay. My lord, my submission, I am ready to give the scheme. On behalf petitioner is ready to give the scheme, which some of the depositors are ready and willing to take back their amount. The state interest is to get the justice. Whether COD or any agency, their state interest is to get the justice. Let them give the depositors list. Let them assist the court. We are also assisting the court.
On this point, my lord, already we have submitted such a list. Originally, when the investigating officer seized the bonds, there were 4,000 odd people which we could investigate. That there are so much investors. Later on, when this court tried to evolve the scheme. We published the notification in the newspaper calling upon, are there any further depositors, they may submit the bonds. That was done with the direction of the court, my lord. And on such a publication of news in the newspaper, there were further people deposited the scheme in the Sen police station, which we deposited in this court, in fact, and the toll rose to 10,200, my lord. My lord, may kindly see the order dated 10/6/2025, my lord. Though we are appreciating the concern to that the amount, at least whatever being deposited, would be returned to the victims. That is the good part. What the petitioners have done in that name, we want to demonstrate before the court, my lord. Kindly see 10/6/2025 order, my lord.
Yes.
It is needless to emphasize that discussion with the investigating agency by the petitioner is utmost necessary to evolve a reasonable scheme. This we gave the consent, my lord. In fact, we are not opposing it. In fact, and therefore, to facilitate
scheme was
this,
given in that.
my lord, therefore, to facilitate this said object, the petitioners are directed to appear before the investigating officer at 2:30 p.m. on 17/6/2025. Lord, to evolve such a scheme, the petitioners number 1 to 3, that is prime accused, who have registered themselves as a partnership, and they get an unauthorized deposit from these many people, which has rose to 260 crore almost. So those people never appeared before the investigating officer.
What attempts were made in
That is what, my lord. They never appeared before the investigating officer, and they never gave their scheme. What is their purpose? What exactly the intent they have? They never appear. Direct them to appear before the investigating officer. If at all they are really bona fide to make this scheme being successful, let them first appear before the investigating officer, and to give them what exactly that amount is being converted into, how many kind of securities. We could identify only few lands. There are many which we don't know. In fact, A1 to A3, in fact, charge sheet which is being filed, that is a preliminary charge sheet filed only against accused number 4 to 8. We have not yet filed. We have written in the charge sheet preliminary charge that they are absconding. Lord, if this is the conduct of the accused, they cannot just simply say that we are giving money and we should be set free. That can't be.
My lord, I am not seeking any concession. My learned friend is telling, yes, of course, in the earlier, before the High Court, the scheme has to be evolved or this thing. Post facto, scheme has not been evolved. That is the issue. I am volunteering myself. Now the petitioner counsel, and I am I am representing the depositor who has set the criminal law into motion in crime number 8 of the Market Police Station of Raichur, which was subsequently transferred to COD, in which the final report has been filed under 173 by the state. I am the complainant. Ultimately, my endeavor is I should get back the money. Of course, there may be thousands of depositors. I'm not denying, my lord. I'm not denying.
There are other depositors.
No, every
There are multiple claims, lordship, in this
No,
case.
my lord, my humble submission is, see, in that TT Antony case, what happened? TT Antony case, if one crime is registered or any number of crimes, it will attach to that. Though I am a depositor, I am the person who has given the complaint, in which the investigation has been complete, final report has been filed, and it has been transferred to COD. It has reached the finality in my case, as whom I am representing. In a sole complaint. See, my learned friend said, yes, paper publication has been any number of depositors who have lost the money, they have definitely approached. See, they are not rich people or anything. They are all bread earners. My endeavor, the court, I expect the state to appreciate a solution towards getting the justice. A short time may be given. We are giving the scheme on behalf of the petitioner. Let them give the depositor. What I am not asking that. My only submission, the COD or any investigation agency has no mechanism to refund back the amount. Only at the SAG industry trial, if the amount is seized, even in the PC Act, the seized amount should be given to PW1 2. This is what we are seeing. My submission is under chapter 23 of the BNSS, the scheme I am not asking, I am asking even the established agency like Legal Service Authority, in who the plea bargaining alternative, we are doing it.
Lordship, one submission. Just one submission.
As
My
per the-
learned friend has said there is several depositors are there, several claimants are there. I undertake before this honorable court all the legal claimants will not be denied for their claim, Lordship. And certainly I'll coordinate with the senior counsel our formative scheme, which will satisfy the claim of each and every legal complainant, Lordship, claimant's Lordship.
Lord, your lordship may ask my learned friend who is appearing in this that whether the investigating officer and the prosecution, we were ready, in fact, we supported the cause, in fact, but no outcome came.
Not that clear.
Appeared before the IO.
Lordship, we always
As per the court order, we have already
But
filed
your
the.
lordship may kindly pass over, just pass over we are seeking. Lord, if at all such an offer seriously, if they are considering, Lord, if your lordship may record kindly the undertaking.
For a scheme which involves around more than 300 crores, I cut short, I can't take any instructions and all. Even if court necessary, I will get even the petitioner's accused number 1, who is 3, A1, 2, 1, 2, 3 are the partners. They should also come on the video conference and they should also undertake before the court, because whenever we make a compromise, they have to be authorities before the court, not mere counsels. We cannot undertake because of the 300 as the officer of a court. I have to be responsible. My humble submission is, we will give a written scheme. We also undertake to keep that accused the 1, 2, 3, because who are the complainant before the compromise petition, they are before the video conference. A date may be fixed, my lord, of 10 days, because the scheme has to be worked out. Only thing, the investigation.
Let the petitioners comply with the earlier order and appear before the IO.
That is
That
what
should be done.
that should act as a condition precedent here in for
You are
involving of any
representing
scheme.
phone number.
Lordship, kindly see the subsequent orders as well, Lordship.
Bona fides of the petitioner should be considered actually. They have to
Lordship,
comply
it is
with the
not
earlier
in,
order.
not in respect of accused, it is only also other authorized person on the behalf of accused person. The order is like that, Lordship, as far as I am aware about the orders. And already
We have
authorized
already
person-
filed the original.
And we already filed the entire
Yeah.
original documents, bonds to show our bona fide. Even we have given the entire details of our other liabilities, Lordship. It is not that we are avoiding
Statements
the
of deposit.
proceedings.
My
We
lord,
had made
my
all
lord,
the formal attempts, Lordship.
I will submit something because I am appearing in this case on behalf of respondent number 3.
Yes.
Similar bunch
That
of
there is
cases,
no
similar bunch of cases are pending, because some of the one of the case, that is criminal petition number 200394 of 2026, already dismissed by this court.
Yes.
Please kindly have the order.
Whether respondent number 3 is in the case.
No, just I have filed the application and I'm pleading. I pray the honorable court that the said application may be kept in abeyance. Unless I accept these accused persons, including of all accused persons, there are 15 accused persons are there who looted the money. There are totally 500 crores. The 500 crores.
Your application for
Lordship
impeding
will
is
keep
pending.
hearing the amount will keep on
Other cases
increasing.
are already pending. Other
My lord,
cases.
he himself is
My-
submitting that can be kept pending for a while. unless
For a
this-
while, yes. So, my lord, my submission is that unless and until the accused persons not be arrested, then the question of justice cannot be determined. This is only the fact, and the money cannot come back. Money has been they absconding after getting the stay order from various cases. They absconding. They're not available to the CID, and also not available. They're not showing the faces in the Raichur city because the poor persons are suffering lot of. The scheme has been implicated by my learned senior counsel. That is, it is very far away from the practical. It is very harder. Unless I accept the accused person not arrested, then justice cannot be determined. This is the main thing. Let the CID may be directed to arrest them immediately.
Lordship, may I submit, Lordship?
Because they are about not known. This petitioner and other persons, whereabout they are not known.
Your application.
Yes, sir.
One.
Proceedings were stayed against them, I believe.
Yes.
Your application.
Were stayed
Your application, I
Karnataka state is one of the parties.
Your application, whether it is pending for consideration.
Yes, pending for consideration. I have filed in the counter. The same may be kept in abeyance. I only pray my lord that the accused persons may kindly be arrested and the stay petitions may be dismissed and also the petitions may be dismissed. Unless I accept not arresting, then the question will not be determined. The justice will not be determined.
Lord, on 25/9/24, the charge sheet has been filed.
Whether you filed wakalat for the applicants.
Yes, I have filed with the application that has been filed in the counter. Some days back on 14th
So and so submits that, yes.
MDK advocate.
Hmm?
Please kindly give directions to CID. Kindly arrest all the accused persons.
Lordship, stay is already there. My learned friend is making the submission. Emotional submission is making
Yes,
to
but
this honorable
okay.
court.
For including the third party is as
Salving the crores together amount, they ran away.
number 3 in the
Then
petition.
my friend has saying something about it.
Designated counsel with the respond number 2 submits it. There is chance of settlement of the matter and hence he seeks.
My lord, my submission may also be recorded. My submission is in retreating the order, the compliance of order dated 10/6.
And he prays time for furnishing the scheme of settlement. However, the learned
SPP.
SPP
Appearing for respondent.
for respondent number 1 submits it, even though earlier this court has passed earlier on 10/6
10/6/2025. my lord.
25. This court has passed the order directing the petitioners to appear before the IGO.
Directing them to appear before the investigating officer.
They have not complied with the said order in the circumstances.
As per the order, petitioner number 2 and 3 has been appeared before the IVO, and accused number 1 is undertaken to appear before the VC lordship because he is on life threatening lordship. He is having a life threatening. 3 days before, his house has set up lies.
Opponents are directed to comply, appear before the IGO in compliance with the earlier order dated 10/6.
Lordship. In respect of petitioner number 1, he may be permitted to appear through the VC lordship.
One more opportunity is given by him. Hence, release
My
the
lord,
matter.
my submission may be recorded.
Lordship, in this matter, there is always several attempts
Major
are
people
made
will get to
to target petitioner's lordship. And for that reason, my learned, I request this honorable court.
respondent is LLB and he submits it. The set IA 1 bar the application file ಮಾಡಿದ್ರು ಅಲ್ಲಿ he submits it. The said application will be kept open for consideration at the latest stage and petitioners may be arrested for the present. In the circumstance, one more opportunity. Next week we'll do 22.
22.
For formulating scheme, we require 2 weeks time, lordship.
In the meantime, you appear for the IO. Yes.
Lordship, petition number 2 and 3 is already appear and comply the order. Only this petition number 1 I need to
Yes.
apply, lordship. He has some genuine issue. He
Yeah.
has
Regarding that, let me hear the IO on the next date. Yes. Madin.
I will file affidavit in that aspect, lordship.
Yes. Who give?
Seal number 16 urgent, seal number 17 Avinash Upalankar.